you will recall that a few days ago, President John Mahama nominated Dr. Johnson Asiama to the high office of Governor of the Bank of Ghana. By the constitutional requirement, in fact, reference is made of Article 1834A of the Constitution. His nomination requires consultation with the Council of State before he can be appointed. This means that Dr. Johnson Asiama cannot legally operate as a governor until such consultation with the Council of State has taken place. Contrary to this constitutional imperative, however, we have seen attempts by Dr. Asiama at the Bank of Ghana to assume duties as if he is legally qualified to do so. Those of us from the minority side, through our leader, have had cause to officially write to the President, pointing out the illegality on the actions by Dr. Asiama and hoping the writing will be done. In a said letter, we drew the President's attention to news reports from various media houses on Monday, February 3rd, 2025, to the effect that Dr. Johnson Asiama has gone to the Bank of Ghana, to all intents and purposes, is behaving as a governor and having meetings with various people and departments. We ask how it is possible for someone who has not yet been appointed, but only nominated, awaiting consultation with the Council of State, to start work. And indeed, when the Council of State has not yet been constituted. Would he have the authority and mandate to take decisions and approve anything that comes to the bank? Would any decision taken by Dr. Asiama as he has taken office have any legal authority? And wouldn't this expose the bank to legal risk? We wonder what the reaction will be if someone nominated to be a judge by the President will go and sit in the court and purport to start administering justice without going through the process set up by the Judicial Council. Supposing the Council of State, when it is constituted, doesn't approve the President's nomination of Dr. Asiama, what will become, or what would be about his presence and activities of the bank in the interim? We humbly suggest that Dr. Johnson Asiama ought to keep well away from the Bank of Ghana until his nomination is approved by the Council of State. Get all the briefing he requires as he awaits his approval. Ladies and gentlemen, we have also noticed that in response to our letter to the President, the Minister responsible for government communication, Felix Ofosu-Pachi, has published appointment letters of previous government officials who were appointed or nominated while waiting for the constitution of the Council of State. We wish to point it out that we are not against the President's act of nominating Dr. Asiama or any appointee pending the formation of the Council of State. What we are against, and we are legally right on, is the fact that the appointee carries on to act when the Council of State is not even constituted. It is a breach of the Constitution of the Republic, and it must not be tolerated. Distinguished ladies and gentlemen, another disturbing issue about Johnson Asiama's appointment is the fact that he was standing trial for various alleged offenses in his previous role as the Deputy Governor of the Central Bank. Dr. Johnson Asiama, former second deputy governor of the Bank of Ghana, until his nomination was standing trial in the courts of Ghana for various criminal offenses, including fraudulent breach of trust, money laundering, conspiracy to commit crime, and violations of the Bank of Ghana Act. Regrettably, these charges were withdrawn by President Mahama a few days to the nomination of Dr. Asiama to the high office of the governor of the central bank. Interesting times indeed. If Dr. Asiama is approved, he would be heading operations and activities of the central bank, which is clothed with the responsibility to check and avert the very crimes he is standing trial for in the courts. Permit me to share with you a statement the central bank shared on Dr. Asiama on August 23, 2019, in response to an interview he had with Joy, and I quote, this is what the central bank said about the person who has been appointed to head the central bank. It is also instructive to note that Dr. Asiama was deputy governor at the time when the decision was taken to revoke the licenses of UT Bank and Capital Bank, and had every opportunity to propose any other strategy for addressing the insolvency of the said banks if he felt there was a better and more effective strategy. His approach before the new management team took over was simply to do nothing in the interest of depositors and the financial institution, and to rather dole out large amounts of public funds to failed institutions whose shareholders dissipated these funds on private ventures at the expense of depositors, employees, taxpayers, and other claimants. They claim that the approach to resolving the two banks resulted in the distress of the savings and loans and microfinance sectors is pathetic, to say the least, with full knowledge that these two banks were connected to other sectors of the financial system. Dr. Asiama and his colleagues were under a duty to take measures they were empowered to take under the law to avert the risk that these two institutions created for the rest of the system. Dr. Asiama also conveniently failed to state the truth at the majority of the IMFs and savings and loans finance houses that failed has started showing signs of insolvency long ago, some as far back as 2012, and as was the order of the day, the do-nothing approach was at play. That Dr. Asiama is going to head the opinion they held about him. In view of the above, it is our considered opinion that Dr. Johnson Asiama be made to go through the full hog of the adjudication of the cases he was standing trial for. We are at a loss as to why President Mahama could not wait for the completion of the adjudication process before appointing Dr. Asiama, or allow the case to still run while he appoints him. It is in the interest of both the states, government, and Dr. Asiama himself to establish whether or not he is guilty of the crimes he has been charged with. For a government that is built from a party with purpose to be lovers of probity and accountability, we firmly believe that President Mahama should allow the charges against Dr. Asiama to stand, even as he carries his duties as a governor when he is finally approved. The action by the president gives us cause to believe that Dr. Asiama is not clean. This silent attempt to discontinue the proceedings of the criminal charges against Dr. Asiama is the more reason why we think he, Dr. Asiama, a potential criminal convict, should not be heading an important and sensitive office as the governor of the central bank. It is even more crucial at a point where Ghana is under an IMF program and requires absolute credibility in our dealings with the IMF. We ask, how would the IMF and the International Finance Corporation see Ghana if one of our